all public prosecution is vested in the DPP.
Initially, the Attorney General's was the home of prosecutions, and then it was a Deputy Director of Public Prosecutions as a department within the Attorney General's office. For that reason, they didn't have the necessary human resources to cover prosecutions, and so the function was delegated to police officers, and that's how we had police prosecutors. Police, of course, as an institution, are an independent investigative agency, and so the making of the decision to charge was not a standalone moment in time in the criminal process, but was a continuum, because the investigator continues to become the prosecutor. And so as the new constitution came in and created the independent office of the Director of Public Prosecutions, then there was a need to actually stop and say, what does it mean to be an independent office? What do we need to establish in terms of processes and systems and policies that would then reflect the independence of the office, as well as protect the mandate of the office.
The role of the prosecutor is to be a minister of justice, and number two is to be just and fair in making that decision to charge, and number three is to ensure that the fundamental human rights are safeguarded for all the parties that are involved when the decision to charge is being made.
When making the decision to charge, the prosecutor is guided by three tests. One, the evidential test; two, the public interest test; and three, the threshold test.
A prosecutor must be satisfied that there is prima facie evidence and that there is a reasonable prospect of obtaining a conviction against a particular individual. And this test is applied particularly in the early stages of an investigation in a case. You must be satisfied that there are certain circumstances that are met before you can make the decision to charge.
It is the single most important decision that a prosecutor makes. It is a life-altering decision, and it must be done in all fairness. It must be done impartially. It must be done in accordance and in adherence to legal provisions, what the law provides.
Then how do we get accountable? We get accountable by ensuring we have standard guidelines, standard procedures on how we exercise prosecutorial discretion. Needless to state, we only have one DPP, but that DPP cannot be in all the courts all the time. And we have 47 counties with prosecution officers. So we must have standard guidelines to guide all the prosecutors to ensure that prosecutorial discretion is not whimsical, it is not personalized, it does not depend on the size of the chancellor's foot. We have guidelines.
What the office had previously was immense experience, but with a pool of 60 prosecutors who were there at the time. But now with shooting up to 600 and now 900, there's need to give proper guidance to all the prosecutors who are handling everyday cases. And that is why the DPP tasked this particular task force to then develop guidelines that would go into near minute detail to guide the prosecutors on how to make the decision to charge.
From witnessing the process of intake of a case, to the arrest procedures of an accused person, to appearance in court, and different case management systems and procedures, the committee returned with new and reinforced ideas of how to improve an intake process in Kenya. And those ideas were used to refine the central intake practices that are incorporated in the decision to charge guidelines.
Some of the challenges that we face are the same. Crime is ever evolving, criminals respect no borders, technology is changing faster than the law, but our fundamental objectives to uphold justice and serve the public remain strong and true.
I want to thank you very much. This is going to be a key step into rolling out ODPP's review of the whole processes and systems that we have in place. It cements the prosecutorial discretion in making the decision to charge. These guidelines therefore not only document but as anchored that discretion that prosecutors practice.
It directs the prosecutor on how to make the decision to charge. It will tell you this is what you're looking for and this is what is sufficient evidence with a reasonable prospect of conviction. What is the public interest? At any particular time in a country, you will know that it is in the public interest that everybody who is guilty where there's sufficient evidence must go to court. And therefore, the DPP continually will give its vision through guidelines, policy documents, and instructions.
What the guidelines have done, under the decision to charge, there is a section that has listed out what is the minimum requirement of a file. And this is not subject to the nature of the offending, it is just because a file has been presented, it must have this. Where you create that, then you have incentivized the investigator to seek alternatives. That if this is something that was petty, then there's alternatives. You can divert the person. You can create some form of reconciliation between sisters who have fought. Unless for some reason it has elevated itself to the place of criminal offending, then can be resolved within the context of their family. So the guidelines require that there would be a certain minimum things, and there would be key evidence. A testimony of the person who has seen or witnessed. There's a testimony of the person who has arrested. There is some sort of, if there is documentary evidence or forensic evidence, that it is present in the file at the time of making the decision to charge.
These guidelines give you a step-by-step guide on what you as a prosecutor are supposed to be looking out for in every single file that comes your way. And it tells you what alternatives are available. And in this way, it enables us as prosecutors across the country to have a certain standard in the decisions that we are making.
This is a significant milestone in the office of ODPP. For quite some time, we have been grappling with the issue of whether we can make standard decisions to charge. As you are aware, we make different decisions on a similar matter as prosecutors, and I believe once we sensitize the prosecutors well, then we are going to have standard way of doing things, and it's very critical for this office as we professionalize our services to the public.
I commend the task force and the implementation committee for your dedication to this process under the unwavering leadership of the director. Because of your hard work and commitment, it will move Kenya towards achieving a more fair and equitable charging process.
The launch of these guidelines today provides the public with an insight behind the prosecutorial curtain. These guidelines have been produced by a dedicated task force over many months.
Couldn't have made it without IJM. They came in and assisted us in the Secretariat, they gave technical support, they gave us resources, and they have also undertaken now to help us in implementation. In fact, we already have an implementation program and guideline. They cooperated with us as if they were part of the ODPP, and we are very, very grateful.